Well, this is a battle over booze between a couple of local restaurants and some of their neighbors. The root of it dates back decades. A 1940s real estate document says no one can ever serve alcohol on the land where the restaurant sits. But you might be surprised what else that document says. News 13's Tim Maestas is on special assignment.
We're not a bar. We're not looking to be a bar. We don't ever want to be a bar. We are a restaurant that serves beer and wine.
And that's the problem. Elisa Young opened up her East Mountains restaurant, the Backside Ale House, a year and a half ago.
We'll see you at Sandia Crust.
Her husband just opened up the Sandia Crust Pizza Company right next door.
And 3 Pinot Grigio.
And both are still placing orders to sell booze, despite the objections of neighbors who filed a lawsuit. The Young say beer and wine help attract customers. And without the alcohol, they doubt the two restaurants would survive.
People do like to come in and either have a pizza and a beer, or they would like to have a burger and a beer.
Customers have a lot to choose from, too. A wide range of beer is on tap, and a long list of wines take up much of the menu. Despite the fact the state issued them a license, neighbors say the Youngs don't have the right to sell beer and wine.
They told me they were going to protest and object based on a deed restriction.
A deed restriction dating back to 1948. That's when the owners of the land where the restaurants currently sit drew up a list of restrictions that stick with the lands to this day. The deed states the land cannot be used for a dance hall, a nightclub, or establishment that serves liquor.
The bottom line is the covenants say that they cannot sell alcohol, and they're still doing so.
Tiffany Roach is one of the lawyers representing the Youngs' neighbors. She says the Youngs and the property's current owners were very aware of the land use restrictions before they bought and leased the buildings. The Youngs say, yes, that is true, but they also point to something else in the deed restrictions that makes them question if those deed restrictions are even legal. Something shocking. The deed restrictions also state the land cannot be owned or used by any person or persons of African or Oriental descent.
I would be ashamed to use that as a tool or a weapon with the racist statements that are made within it.
The fact that stuff like that is still around, valid or not valid, is I feel, unjust.
According to the lawyers representing the Youngs' neighbors, the Supreme Court ruled years ago that racist language like the kind contained in the deed restriction is illegal. But they say the rest of the deed restrictions are still valid.
There is nobody on our side that is trying to enforce the covenants or even those racial covenants or even bring them up.
In fact, the second attorney representing the plaintiffs is African American.
The solution there isn't to throw the baby out with the bathwater and say that the entire deed is unenforceable. The solution is to simply ignore the language that is offensive and unenforceable, and the rest of the language in there conveying the property rights would then be enforceable.
That will be up to a judge to decide once the case goes to trial in June. In the meantime, the neighbors' lawyers have requested a temporary restraining order from the court.
We're asking the judge to order that they stop serving alcohol until it can be decided at trial.
A hearing on the restraining order has not been set yet. The Youngs say they will not stop serving beer and wine in the meantime unless a judge makes them. They insist doing so would force them to shut down.
I would have to. I don't see any other options for locations that I could move to.
My fate and the fate of all of our employees is in the hands of a judge. The East Mountains is growing. It is not 1946 anymore. It is 2011.
Tim Maestas, KRQE News 13.
The Youngs operated a restaurant in that same building back in the 1990s, and they say the neighbors did not complain about the booze they were serving then. The neighbors' attorneys say their clients did complain, but the restaurant closed before they had a chance to sue.